Welcome to Political Science 201 with Laura Fleming. This is our lecture number 6 about the presidency. Okay, so just to get us started, I'd like you to reach back to your high school civics class and think about what are the requirements to run for president. The presidency is described in Article 2 of the Constitution. Remember that Congress is the focus of Article 1. Now we've moved on to Article 2. And the question is, what are the requirements to run for president in Article 2? So you may remember something like a president has to be at least 35 years old. A president has to be a natural born citizen of the United States, a citizen since birth. So we're going to talk about these and other requirements. We're going to talk about the presidency today, how the president is elected. It is not a direct election based on popular vote. It is actually through this intermediary device called the Electoral College. We'll talk about why that is. We'll talk about some of the powers of the president. So the president is very powerful. However, his powers are limited, and some of his powers are shared with other branches, specifically the Senate. So we'll talk about that. We'll talk about impeachment. What's the process for impeachment? What are the potential reasons for impeachment? Finally, we'll begin our discussion about the bureaucracy. Okay, so the president is not the only member of the executive branch of government. We actually have a cabinet, which is composed of the president's advisors and the heads of government departments. And we also have something called the EOP, Executive Office of the President, advisor. It's kind of an advisory board to the president. So we'll get into that discussion, and that's kind of the tip of the bureaucratic iceberg that we'll get more into next time. So Article 2 of the Constitution establishes the presidency, and you can find Article 2 right on page 103 of your accessible Federalist. It says the executive power shall be vested in a president of the United States of America. He shall hold his office during the term of 4 years. And then it goes on, talks about how old the president has to be, which is 35 years old. Remember, a member of Congress has to be 25 for representative in the House and 30 years old for the Senate. President is even older. That's the age of 35. You have to be 35 to be president. Seems like with our recent presidential candidates, this has not been a problem, right? They're in their 70s. But you have to be at least 35. You have to be a natural born citizen. You are up for re-election every 4 years. So remember, members of the House of Representatives are up for re-election every 2 years. So every other election cycle is a presidential election cycle. Now, one thing that's interesting about the presidency is that there are term limits. There are not term limits for members of Congress, as we talked about. Members of Congress can be reelected over and over and over, and many times are. So members of Congress can serve for decades until, some challenger miraculously beats them or they retire from public life. That's not the case for the president. The first president, George Washington, served 2 terms. And then he bowed out of public service. And it was kind of traditional for presidents to serve 2 terms, but there was nothing in the Constitution prohibiting presidents from serving longer. Then during World War II, we had a very powerful president, FDR, Franklin Roosevelt. He was a 3-term president. And I think in the aftermath of FDR's presidency, the American people felt, wow, that was a lot of power to one person. And, if 2 terms was good enough for George Washington, it should probably be good enough for anybody. And so we came up with this 22nd Amendment that presidents may only stand for election twice. So this means generally you only get 8 years. Now there's kind of a little brain teaser of a question, and that is, what if you become president because God forbid you were the vice president and something happens to the president and he dies and you become president? Okay, and let's say that after you've served president for the remainder of the previous president's term, then you're elected president in your own right. So the question is, can you stand for re-election a second time? Okay, so how much time do you get if you started out with only a partial term? And actually, it's kind of interesting. The 22nd Amendment splits the difference. Okay, so this is on page 116 of your Accessible Federalist. No person shall be elected to the office of president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of the president more than once. So, if you served more than half of the previous president's term, that counts, and you only get to run for election one time. But if you serve less than half of the previous president's term, then that does not count, and you get to stand for election twice. Okay, so technically you could squeak by with 10 years as president, but only if you served just under half of the previous president's term because you were the vice president. Okay, so there's a little nuance there, but in general, presidents are limited to 2 4-year terms or a total of 8 years. Okay, I'd like to take a look at Federalist Essay 70. This is in your Accessible Federalist starting on page 59. And the question is, what are the differences between Congress and the president? The biggest difference, and this is kind of a duh, is that the president is one person, whereas Congress is made up of many people. You know, we don't think very much about that today. We think, of course, the president is only one person, but the founders thought about this. They thought about, you know, should we have co-presidents? Should we have some kind of executive committee? And the founders said, no, that's not what we want. And the reason that they didn't want more than one president is because they wanted the president to be efficient. Okay, so take a look at page 60. I'm going to read this to you. No one will deny that unity, meaning being just one person, leads to efficiency. Decision, activity, secrecy, and effectiveness will usually be more characteristic of one man than of any greater number. And as the number is increased, these qualities will decrease. So they wanted the president to be efficient, to make quick decisions, to be a man of action, and to be able to keep secrets if necessary. This is the opposite of Congress. If you turn over to page 62, here's Federalist 70 again. In the legislature, speediness of decision is more often an evil than a benefit. So he's saying that actually we don't want Congress to be too efficient. We talked about that, the fact that it's so hard for a bill to become a law, and there's lots of discussion and deliberation and debate. Congress is not and never will be a model of efficiency. And the founders were okay with that. They said differences of opinion and party conflicts in Congress, though they may sometimes hinder good plans, yet often promote deliberation and caution, as well as provide a check on excesses in the majority. So they said we want our legislature to discuss and deliberate because we don't want too many laws, and we especially don't want bad laws, laws that come down too hard on some political minority. Okay, so we made Congress purposefully inefficient. But Hamilton says no positive effects make up for the disadvantages of disagreement and conflict in the executive department. He says we want a president with vigor and effectiveness, especially if you're talking about war. Okay, we'll talk about the fact the president is our commander-in-chief. God forbid Congress had to direct the day-to-day activities of the military. Okay, so that's not the place for discussion and debate. When we're at war, it's the time for efficiency and action. In addition, the founders wanted to make clear that the buck stopped with the president. And when you only have one president, it's pretty easy to tell who screwed something up. Okay, this is page 63. It says, it often becomes impossible amid mutual accusations to determine where the blame or punishment for harmful measures should fall. It is shifted from one to another with so much skill and plausibility that the public opinion is left in suspense about the real author of the measure. So we all have this vague feeling that Congress is not doing its job, but it's really hard to tell who's at fault. And so we keep re-electing the same members of Congress over and over again. So Hamilton says we don't want that with the president. Okay, he says we want the ability to discover easily and clearly the misconduct of the persons that we trust in order to either remove them for office or charge them with actual crimes. It is far safer for there to be a single object for the suspicion and careful observation of the people. A single individual, from the very circumstance of his being alone, will be more carefully watched and more quickly suspected. He will also be incapable of exerting as much influence by himself as he is able to in association with others. So you can see how much scrutiny, for example, President Trump gets. He gets a lot of scrutiny from the media, people watching his every move. And the founders would have been okay with that because they felt that the buck should stop with the president. The president should be able to act with efficiency and decision, but at the same time, be easily identifiable and held accountable for his actions. So that's the main difference between Congress and the president. Congress is supposed to be a little sluggish, debate, deliberate, argue, disagree, whereas the president, being only one person, is supposed to be a leader with action, efficiency, and dispatch. So the founders, to summarize, gave executive power to one president. One person has more energy. That was the old word used in the original Federalist Papers. Professor Seagrave has updated that word, so now SA 70 uses the word efficiency. One person has more efficiency than multiple people. One person has more accountability than multiple people, so the buck stops with the president. But they had to do a little assurance to the American people. Okay, they had to say, don't worry. The president has limited powers. Okay, the president is not going to be like a king. So we're not recreating a British-style monarchy here. It's still a limited government. So here's Hamilton. This is in SA 69, which is not included in your Accessible Federalist. I'm just going to read a little bit here. Hamilton is comparing the powers of the president to the powers of the king. He says, first of all, President of the United States will be an officer elected by the people for 4 years. The King of Great Britain is a perpetual and hereditary prince. Obviously, the British monarch is born into the position and serves in that position indefinitely, whereas the president is elected to 4-year terms. Hamilton goes on, the president is amenable to personal punishment and disgrace. The monarch is sacred and inviolable. Okay, so the British monarch has a special place in society. Can't really get in trouble if you are the king, but you can definitely get in trouble if you're the president. He says, the president does have a veto, but it's limited. Congress can override the president's veto, but the King of Great Britain had an absolute veto over Parliament. The president is our commander-in-chief, does have a right to command the military and naval forces of the nation, but the King of Great Britain can also declare war and raise money and regulate the military by his own authority. We'll see that the president shares war powers with Congress, unlike the King of Great Britain. The King of Great Britain does not need to share war powers with Parliament. Hamilton goes on, he says, president shares the power to make treaties, the president shares the power to make appointments. The president, again, cannot make nobles or lords and ladies and dukes and duchesses, etc. Goes on. In addition, thankfully, the president has no particle of spiritual jurisdiction, but the monarch is a supreme head and governor of the national church. So Great Britain has a national church, and the monarch is at least the figurehead of the national church. So thankfully, our president doesn't have any kind of spiritual power or jurisdiction. Hamilton says, look, what answer shall we give to those who would persuade us that things so unlike resemble each other? He's getting frustrated. He says, if you can't see the difference between the president and the King of Great Britain, you're not going to be able to see the difference between government by the people and a monarchy and a despot. Okay, so that is the Federalist Papers, essay 69 and 70. Okay, so what's interesting about the president is that he is not elected by popular vote, so they don't tally all the votes from across the United States. Instead, we have this electoral college system where we vote state by state. Okay, so each state is assigned a certain number of votes called electoral college votes, and that's how the election works. Let's walk through this a little bit. Electoral college allows states to have a unified vote. So basically, it allows each state to have an impact as a state. The number of electoral college votes is based on the number of members in Congress. So if you take a look at Louisiana, remember we talked about the fact Louisiana has 2 senators and 6 representatives in the House. So this means that Louisiana gets 8 electoral college votes. So you'll see that the smallest states like Alaska and Montana and North Dakota and South Dakota, Wyoming, etc., they only get 3 electoral college votes, and the larger states like California has 55 electoral college votes, Texas has 38 electoral college votes, etc. Plus, remember the 23rd Amendment, which gave residents of Washington, D.C. the right to vote for president. We talked about the fact that as the national government grew, the nation's capital also grew, and the residents of Washington, D.C. started agitating to vote for president, and the Constitution was amended to allow them to do so. So Washington, D.C. has the same number of electoral college votes as the smallest state. There may be one or two states that split their electoral college votes. For example, Maine, you can see that Maine has a little red spot on it. That means that Maine split its electoral college votes, but for the most part, states will have a winner-takes-all system. This means if the majority of the population of the state votes for a particular candidate, even if it's just a slight majority, that candidate will get all of the state's electoral college votes. And this gives the states, a significant amount of power that they can wield as states. Previously, the Electoral College was made up of, actual people, electors. So the states would vote for electors, and then the electors would actually get together and they would vote for president. Today, the electors are just figureheads, and they're really pledged to vote for the candidate for president, the candidate that receives the most votes in their state. So today, we do have electors. They're more ceremonial. They're pledged to give their vote to the particular candidate that wins the most number of votes in their state. Okay, so the electors don't really have the same kind of independent responsibility that they used to. So the total number of electors is 538. Remember, there's 435 members in the House of Representatives, plus 100 senators, plus 3 electoral college votes for Washington, D.C. That's 538, which means that you need 270 electoral votes. That's the majority of the 538 to win the presidency. And you can see from this map, Trump, in the last presidential election, he had 306 electoral college votes, so significantly more than he needed to beat out Hillary Clinton, who only had 232 electoral college votes. So you can see the breakdown on the map, and you can notice the areas that are blue. They tend to be the highly populated coastal areas, California especially, and also over on the East Coast. Now, every once in a while, the Electoral College vote may be different from the popular vote. Most of the time, the candidate that wins the majority in each state will also win the majority of the popular vote, but that's not every single time. And we understand this because the Electoral College formula is a different formula from the popular vote. So different formulas can get you different results. So in the 2016 election, Hillary Clinton did receive more total votes. And this is because there were large urban population centers that voted for Hillary Clinton in large numbers. And this was smoothed out by the Electoral College system. So Clinton received 65 million, almost 66 million votes, about 48% of the popular vote. And Trump only received 63 million total votes, 46% of the vote. But Trump did win the Electoral College, and he did win the presidency. And so some people think, that's really not fair, right? Why is it fair that Trump became president even though he got fewer total votes? Well, the founders did this on purpose, okay? They did this on purpose, and there's basically two reasons. One is federalism, so that the founders liked the idea that the states would be voting as states, that we do have these sovereign states. The state entities do mean something, and we show that we respect the significance of each state by allowing each state to vote as a unit. Okay, so the presidential candidates have to focus on the needs of each state. That's number one. Number two, let's imagine Some people are calling for the abolishment of the Electoral College. Elizabeth Warren, in particular, said that she wanted to be the last president elected by the Electoral College, right? So what would happen if you got rid of the Electoral College? What would happen is that the campaign of these presidential candidates would look very different. Okay, so they would actually focus their campaign on the big cities. So you would see the presidential candidates having their rallies in Los Angeles, San Francisco, New York City, Chicago, maybe Miami or something like that. But the rural areas where you don't have very many voters would be completely ignored, right? The president would really skew toward the desires and the needs of the urban, highly densely populated areas. And the founders did not want that. They thought that the nation needs to consider not just the interests of its cities, but also the interests of its rural areas and its farmers. And so this is kind of a small thumb on the scale in favor of rural areas. And at least, you know, for those of us who live in Louisiana, we should be grateful for that. This is part of the compromise, the great compromise at the heart of the Constitution between the highly populated states and the less populated states, is that we have this electoral college system where it's not a straight popular vote for president. Okay, let's talk about the powers that the president holds. President holds significant executive powers. President is our head of state, and the president has the power to sign treaties with other countries. Now, this treaty power is shared with the Senate. So that's in Article 2 of the Constitution. Article 2, Section 2 talks about the powers of the president. He shall have the power, this is page 105 of your accessible Federalist, he shall have the power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. So binding treaties must be approved by 2/3 of the Senate. So we didn't want the president running around signing binding treaties with other countries unilaterally. Now, very difficult to get 2/3 of the Senate to agree on something, so presidents do have kind of a workaround. This workaround is called an executive agreement. Okay, executive agreements are somewhat less formal than treaties, and they do not require 2/3 approval by the Senate. Basically, an executive agreement is just an agreement signed by the president personally. Okay, so the president is personally agreeing that his administration will abide by a certain agreement with another country. Okay, the problem with executive agreements is they're kind of easy come, easy go. So if one president signs an executive agreement, it's quite possible that a future president would repudiate that executive agreement, whereas a binding treaty confirmed by 2/3 of the Senate has more weight. So take, for example, a couple of the agreements signed by President Obama. President Obama signed our agreement to the Paris Climate Accords. Okay, so those were agreements about certain climate change mitigation goals. And President Trump thought that those agreements were not good for the country, and he revoked his agreement. He could do that because it was just an executive agreement signed personally by the president. It was not a binding treaty approved by a supermajority of the Senate. Likewise, President Obama signed an agreement with Iran, and President Trump thought that that was not a very good agreement, and when he became president, he revoked it. Okay, again, he was able to do that because it was not a binding treaty. It was just a personal agreement with between Iran and the president at the time, President Obama. Okay, the president also shares war powers with Congress. This is very interesting. Under Article 2, Section 2, it says that the president is our commander-in-chief. So let me pull that up real quick here. I'm reading from the Constitution, page 104 of your Accessible Federalist. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. So remember, we talked about the fact that the President has to be efficient, has to make quick decisions, be speedy, so that's why the President is the Commander-in-Chief and not Congress. However, so the president is our commander-in-chief, but under the Constitution, only Congress can declare war. Okay, and not only that, only Congress can raise funding for defense activities. So this is in Article 1, Section 8. This is the list of the powers of Congress. And one of the powers of Congress is to declare war, to raise and support armies, to provide and maintain a navy, etc. Okay, so the president doesn't have sole war powers. The president is subject to the budget. That, remember, we talked about the budget process last time. Congress comes up with the defense budget, okay, the amount that we're going to spend on our military. And the president has to, the president can veto it, but ultimately he has to reach an agreement with Congress on military spending. Likewise, only Congress can actually declare war with another country. Now again, Congress, gets stuck, they get gridlocked discussing and debating, and there's workarounds for this. Again, you can wonder, when was the last time that Congress actually declared war? And the answer is Congress has not specifically declared war since World War II. And you may ask yourself, well, what about the Korean War? This picture on the slide is a picture from the Korean War. What about the Korean War, the Vietnam War, the Cold War, the war in Iraq, etc.? So America, nonetheless, continues to deploy troops around the world. Okay, war is very controversial, and so members of Congress are really have kind of been reluctant to make decisions about war, to declare war, or to even, vote not to declare war, right? So members of Congress have been pretty reluctant, especially since the Korean War and the Vietnam War, where America did not do very well in those wars. Wars become kind of a disfavored activity among voters. So it's very political. Congress is reluctant to specifically declare war. Nonetheless, we continue to deploy troops around the world. So, nonetheless, we have this military, we have this defense budget and defense machinery, and it keeps operating, and the president keeps sending our troops around the world, even without a specific declaration of war. So we kind of have this sort of low level of constant conflict around the world without the kind of clear declaration of war and clear objectives even of war that you might like to see. And this is kind of an example of how the powers of the president and of Congress have gotten a little out of balance since the time of the founders. Let's talk about another shared power that the president has, and that is the appointment power. The president holds the power to appoint Supreme Court justices and other officials. But appointments have to be confirmed by a majority of the Senate. Okay, this is one of these shared powers. This is part of the senatorial trust that we talked about, the special job of the Senate. So we've seen that the Senate has to approve treaties by a 2/3 majority, and now we're seeing that the Senate also has to approve the president's appointments. Okay, Supreme Court justices are some of the most important appointments that the president has, because Supreme Court justices do not have terms. Okay, they can serve for life, and many Supreme Court justices serve for decades, right? So here is President Trump. He nominated Judge Neil Gorsuch. This was Trump's first nominee to the Supreme Court. It went pretty smoothly. He nominated Justice Gorsuch to replace Justice Antonin Scalia. Scalia had been appointed by Ronald Reagan. Okay, Scalia had been on the Supreme Court for decades. So you can see that appointments to the Supreme Court are a very important part of the president's legacy. They significantly outlast the president's time in office, or they can. The second appointment President Trump made, he was also replacing a Reagan appointee, Anthony Kennedy. Kennedy retired. President Trump appointed Justice Brett Kavanaugh. That was a lot more controversial. So we'll get into the appointment process more when we talk about the federal court system, when we talk about the Supreme Court. But for now, just remember that the president holds the power to make appointments, especially appointments to the Supreme Court, and that he shares this power with the Senate because the Senate generally has to confirm or approve these appointments. President also has the power to do something called executive orders. Now, in general, the president is not supposed to be making the laws, right? So Congress is responsible for making the laws, and the president technically is supposed to enforce the laws, not make the laws. So executive orders are a kind of lawmaking that we allow the president to perform because we see it as part of his executive or enforcement powers. Executive orders are not in the Constitution, but many presidents have used executive orders. They allow the president to take quick action without involving Congress, and many powerful presidents have used executive orders. Probably the most famous executive order that we've talked about is the Emancipation Proclamation by President Abraham Lincoln. Okay, you remember that Lincoln issued an executive order as part of a wartime measure freeing the slaves in the rebel states. Okay, that was the Emancipation Proclamation. Woodrow Wilson, an early progressive president, issued 1,803 executive orders. FDR issued 3,522 executive orders. So executive orders are generally accepted if it does not conflict with the Constitution or with existing law. One of the problems with executive orders is, like executive agreements, they're kind of easy come, easy go. This is why we didn't want to leave setting the slaves free up to the Emancipation Proclamation only. We wanted to have a constitutional amendment to incorporate it into the fundamental law of the land. Executive orders are signed by one president, and they can be revoked by one president. In 2014, President Obama took executive action offering legal status to about 5 million undocumented immigrants. Okay, these were the dreamers. So President Obama unilaterally offered legal status to these immigrants who had come here unlawfully, but through no fault of their own because they were still minors. Okay, so Congress was having a very hard time reaching agreement on immigration. It's a very controversial topic. So President Obama famously said, you know, I have a phone, I have a pen. If Congress won't act, then I'm going to go ahead and get stuff done my way by executive order. I would encourage you to click on this hyperlink here, and it's actually a Saturday Night Live skit, or you can just Google Schoolhouse Rock Saturday Night Live executive order. So remember, we talked about the original Schoolhouse Rock with the poor little Bill. I'm just a bill on Capitol Hill. Someday I'll be a law. And his perilous journey through both houses of Congress and the committees and the arguing, discussing, and debating, and finally to the president's desk. And this Saturday Night Live skit's very funny and actually, you know, quite thought-provoking because it shows the executive order saying that, you know, Bill, you don't have to go through that whole long process. You can just have the president create you and boom, you're a law. Okay, so there you can challenge executive orders if the president is overstepping his bounds, if the president is not writing an executive order that's in agreement with the laws passed by Congress or with the Constitution, then you can get lawsuits that challenge that executive order. We did see that with the DREAM Act. And eventually, President Trump revoked President Obama's executive order and basically forced Congress to come up with a compromise. Here's a thought question. Should the president be allowed to keep secrets from the American public, and under what circumstances? When we think about secrets kept by the president, probably the first thing that comes to mind are issues of national security, right? So we don't want the president going around blabbing things that might jeopardize our military actions abroad or jeopardize our, you know, military secrets or technology. So we could probably all agree if it's an issue of national security, the president should be allowed to keep that secret. In fact, we would want the president to keep that secret. With respect to other things, you know, some people might ask, should the president's personal life be kept secret, right? We'll talk about the fact that Bill Clinton's personal life was very public and the subject of an impeachment. Is that a good or bad thing? Should we really care about what the president does in his personal life? You know, reasonable minds can differ about that. But again, you know, the president is a public person, and many times under the law, when you have a public person, they kind of waive some of the privacy rights that you and I, ordinary citizens, enjoy. Okay, so when we think about secrets, we might think about national security, we might think about issues of privacy, but today we're going to talk about a different kind of secret called executive privilege. Very interesting, actually doesn't have anything to do with the president's privacy, and it's not just for reasons of national security. So we'll talk about that. So the president can invoke something called executive privilege to keep certain conversations confidential. This term privilege does not refer to the perks of the president's office. It doesn't mean the president gets to eat all the ice cream he wants, for example. It doesn't mean the president has white privilege or anything like that. Okay, privilege is a legal term. And a privileged communication is legally protected. So basically, it's certain conversations where you have this legal cone of silence that descends and nobody can make you disclose what you talked about. So for example, the most common type of privilege you may have heard of is attorney-client privilege. So attorneys and clients can speak freely to each other and nobody can make the attorney or the client disclose what they said to each other. Okay, so you can be reassured if you say something in confidence to your attorney that is legally privileged and your attorney has the ability to keep that completely confidential. This is a good thing if you're an attorney. You want your client to be honest with you, okay? You don't want to get into court and have a situation where the other side is asking questions and all of a sudden you're finding facts out for the first time, bad facts, and you had no chance to prepare for them, okay? You don't want that to happen. You want your client to be honest with you, tell you all the facts, including the bad facts, so that you can provide a good defense and nobody has to worry about the attorney being forced to tell on the client. Other kinds of privilege. There's a marital privilege, okay? So you can't force a husband or a wife to testify against the other spouse. And again, this is a relationship that's legally protected. The marriage relationship is legally protected because we believe it's a good thing for spouses to be honest with each other, and it's a bad thing to force a spouse to be disloyal to their husband or wife. And so anything that you say to your husband or wife is legally privileged. A doctor-patient privilege, so the things that you tell your doctor, they may be embarrassing, but they're legally privileged and legally confidential. There's also something called a pastor parishioner privilege or a priest penitent privilege, and it basically means if you go to confession or you go talk to your pastor and unburden your soul, that the police are not going to be able to force your priest or your pastor to testify against you. Obviously, there are going to be certain limited exceptions, okay? So if you tell your attorney that you're actively planning to murder your professor, right? And you tell the attorney when you're going to do it, etc. In that case, if somebody's life is in immediate danger, then the privilege does not apply and the attorney should let your professor know. Okay, so privilege is not absolute, but it's very common in these kinds of relationships that the law wants to protect. So the president has something called executive privilege. Executive privilege protects communications between the president and certain advisors. And the goal is sort of related to national security, but only indirectly. Okay, the goal is to encourage honesty between the president and his advisors. The thought is that if these conversations between the president and his advisors, for example, here's President Trump with his former national security advisor, John Bolton. So the idea is that if these conversations with the president's advisors are privileged, are confidential, then the president and his advisors are more likely to be completely honest with each other, not worried about what the media might think or what other people might think, and that is a good thing for the country. So we want the president's advisors to be honest with him and vice versa. We want him to be honest with his advisors. Therefore, we give these conversations legal privilege, this cone of silence, allowing them to keep those conversations confidential most of the time. Okay, let's do a quick review. The president, Congress, and the judiciary check and balance each other. Remember, our founders were maniacs. They were maniacal about checks and balances. The president can veto a law passed by Congress. So even if Congress really wants to pass a law, they still have to get the president on board. The president has the power to appoint judges, but as we've seen, that the appointment power is shared with the Senate. That's part of the Senate's senatorial trust. Then we have judges. Judges are quite powerful. They can declare the actions of the president or Congress unconstitutional. So if a judge feels that an executive order or a law passed by Congress do not conform to the U.S. Constitution, the judge has the ability to nullify or strike that law down. We'll talk more about that when we get into the judiciary later in the course. Congress, of course, can override the president's veto. So the veto is not absolute, it's limited. If Congress really wants to pass a law, they can get a 2/3 majority and override the president's veto. Congress can also impeach the president, which we'll talk about in just a minute. So Congress can actually accuse the president of wrongdoing and get him removed from office. And the Congress can also impeach the president's appointment. So we'll get into these things a little bit more, these checks and balances, these abilities that the different branches have to get all up in each other's business. Let's talk about the veto. The veto makes it even harder to pass laws. We've seen how hard it is to pass laws in Congress. Congress often gets gridlocked from discussion and debate, and the veto makes it even harder. But the founders actually did not mind this. Okay, this was part of their maniacal plan. Okay, they believed that less is more. And this is Hamilton in Federalist Essay 73. He says, it may perhaps be said the power of preventing bad laws includes that of preventing good ones and may be used to the one purpose as well as to the other. So he recognizes that president may veto a perfectly good law, but he goes on, he says the injury which may possibly be done by defeating a few good laws will be amply compensated by the advantage of preventing a number of bad ones. He says, you know, I don't mind if a couple good laws get screened out as long as the bad laws are also screened out. So the idea is that less is more. Fewer laws are better. Hamilton goes on, he says, it's evident there would be greater danger of the president not using his power when necessary than of his using it too often or too much. So Hamilton wasn't worried about the president using the veto too much. He was actually worried about the president not using the veto enough. Okay, so they really believed fewer laws were better. Let's talk about impeachment. Congress has the power to remove the president from office in a two-step process. Okay, so the first question you might ask is, you know, what would be the reasons, the constitutional reasons for removing a president from office? This is in Article 2, Section 4. So let me find Article 2, Section 4. It's on page 104 of the Accessible Federalist. It says, the President, Vice President, and all civil officers of the United States, so it's not just the President can be impeached, the Vice President and other officers can also be impeached, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Okay, so if the president commits treason, we definitely don't want a president that's going to be disloyal to the United States and conspire with another country. Bribery, we don't want a corrupt president, a president that's going to sell favors. That would not be good. And then there's this miscellaneous category, other high crimes and misdemeanors, just means other serious crimes. So treason, bribery, other serious crimes, that's enough to start the impeachment process. First, remember it has two parts. First, the House of Representatives issues the articles of impeachment. So this is a document outlining all of the things that the president supposedly did wrong. And you can see why this process starts in the House. So the House is generally younger, they're a larger group, closer to the will of the people, so kind of the rabble-rousers in the House gets fired up and they want to impeach the president. And so they come up with a document called the Articles of Impeachment that lays out what they think the president did that was wrong. Now, just because the House of Representatives impeaches the president does not mean the president is removed from office. We saw this when President Trump was impeached recently. So House of Representatives is majority Democrat. The Democrats were bent on getting Trump out of office, and so they issued these articles of impeachment. They said that Trump had been obstructing Congress and abusing his power. But Trump was not removed from office over that because, second, the president must face a trial before the Senate. Okay, this is part of the senatorial trust. Again, the Senate is entrusted with trying the articles of impeachment. So the Senate has to hear evidence and decide, okay, did the president do the things that the House of Representatives has accused him of, and are these things serious enough that the president should be removed from office? And conviction requires 2/3 of the Senate. So to get a president actually removed from office, not only do you have to have a majority of the House of Representatives sign off on these articles of impeachment, you have to have a supermajority of the senators agree that the president was guilty of sufficient wrongdoing that he should be removed from office. So actually only 3 presidents have been impeached by the House, including Trump. No president has been convicted by the Senate, so no president has actually been removed from office because of impeachment. Before Trump, we had Bill Clinton, okay, back in the 1990s. Bill Clinton was, let's see, he had a reputation for womanizing, and some of these women came forward and accused him of harassment, and he was sued, and he testified under oath in these harassment cases, and there was a concern that he had lied and tried to obstruct justice that these women were trying to obtain against him. And along the way, as sort of this tangled web was unwoven, we had kind of a little sideshow involving Monica Lewinsky, who was the mistress of the president, a young intern while he was in office. So the whole thing was very scandalous. And the House of Representatives approved articles of impeachment alleging perjury and obstruction of justice. In the end, Bill Clinton did face a trial in the Senate. The Senate did not convict him. The Senate did not remove him from office, and he went on to have a fairly successful presidency. Okay. So you may be wondering, who was that third president that was impeached? Some people think it was Richard Nixon. Okay, Nixon was involved in the Watergate scandal, spying on the Democratic Party. He definitely would have been impeached and most likely removed from office. But Richard Nixon kind of realized that he was going down, and he actually resigned from office before he could be impeached and removed. Okay, so Richard Nixon actually did not go through the whole impeachment process. He resigned. The previous president that was impeached, this goes all the way back to the Reconstruction era. It was President Johnson. Okay, President Johnson, who was, this was Abraham Lincoln's vice president. It wasn't Lyndon Johnson. It wasn't LBJ. This was Andrew Johnson. Andrew Johnson was vice president under President Lincoln, and then he became president, and he had kind of a showdown with Congress. He had a little bit different ideas about Reconstruction policy. They impeached him in the House. They tried to convict him, but did not have the supermajority in the Senate necessary to do so. You know, it's very interesting, the Trump impeachment. The Republicans were a majority in the Senate during this time, and so it was very unlikely that President Trump would be removed from office. It was kind of a doomed mission that the Democrats in the House of Representatives were engaged in, and you know, the conclusion is that they were simply trying to draw attention to the issues they didn't like about President Trump. But it was very unlikely that Trump was actually going to be removed from office, because conviction requires 2/3 of the Senate, and the Republicans had the majority in the Senate. So let's talk about the cabinet. Cabinet is made up of the heads or secretaries of federal government departments. So the idea is that the president doesn't operate all alone, that the president is going to need some advice and counsel and some help administering government departments. In Article 2, Section 2, this is on page 104, says the president may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices. So the assumption is that we're going to have various executive departments, and that these executive departments are going to have officers. Today we call them secretaries, and that the president is going to rely on their opinions from time to time. And now, this is a picture of President Washington's cabinet. It's very small. If you click on some of these links, so click on the link up in the title there, that is a link to President Trump's cabinet. And you'll see President Trump's cabinet's much bigger, maybe 20, 25 people all sitting around the table. You can also click on this picture here, and under the picture there's a link to a little video, and this video is it's kind of a puff piece, but it's pretty interesting. It's about President Obama's cabinet. Okay, so it's kind of a little vignette or snapshot of a cabinet meeting, and a little bit about the history of the cabinet. So it's pretty interesting, and you'll see in President Obama's cabinet Hillary Clinton playing a big role. Hillary Clinton was the Secretary of State. So that's a very important role in the president's cabinet. Okay, so the cabinet is made up of the heads or secretaries of federal government departments. It was created by the Constitution, so it was assumed that the president would need these advisors. But again, you know, in the beginning, cabinet much smaller. Cabinet members are appointed by the president subject to Senate approval. So these heads of the departments, these secretaries, are very important positions, and they're subject to Senate approval. Again, Washington's cabinet, very small. Today's cabinet, much bigger. Now, the president has more advisors than just his cabinet. There is another office called the Executive Office of the President, or EOP, and if you click through that link at the top, then you can see President Trump's executive office. These are also advisors who support the president. So the EOP was established by Franklin Roosevelt in 1939, and this is different from the secretaries of the major government departments. These are the president's closest policy advisors, and basically all they do is advise the president. They're not heads of government departments. They're not confirmed by the Senate. They're just the president's closest advisors. We talked about the fact that the president has to prepare his budget recommendation every February, and that the president doesn't have the time, perhaps doesn't have the background to crunch all those numbers by himself. So the president has something called the Office of Management and Budget. Office of Management and Budget is an example of a section of the EOP, these executive offices, these support advisors for the president. Okay, why do you think FDR felt the need for the EOP? Well, FDR was very aggressive with his progressive programs. Remember, he was proposing a New Deal. He was very active. He needed advisors, and perhaps he wanted advisors that would be loyal just to him. Perhaps he wanted advisors that were not distracted by running big government departments, and perhaps his advisors may not have met the approval of the Senate. Okay, maybe his advisors were a little more radical than the Senate might have wanted, and so FDR wanted an office of his own personal advisors that he could rely on without worrying about their acceptability to the Senate, and without worrying about their interests being divided with running government departments. Okay, here we have an org chart for the federal government, and we see that most of the federal government is bureaucracy. Very interesting. So here at the top we have the Constitution. Okay, so our government flows out of the Constitution. The Constitution is our governing document. Underneath the Constitution we have these three branches: legislative branch, executive branch, judicial branch there. Okay, we talked about that. And then what is all of this stuff at the bottom of the org chart, the bottom half of the org chart? Okay, here in the middle we have the 15 major government departments: Department of Agriculture, Department of Commerce, Department of Defense, Department of Education, and so forth. These are the departments that are headed by people called secretaries that are all members of the permanent cabinet. Okay, so very important major government departments. And then at the bottom we have an additional, several dozen, umpteen independent establishments and government corporations. Okay, these are the alphabet soup of government agencies, like the CIA, Central Intelligence Agency, the EEOC, Equal Employment Opportunity Commission, the FCC, the FDIC, the FEC, so on and so forth, the Peace Corps, the Post Office, NASA, all of these different various government organizations, to the point that most of the federal government is bureaucracy, and you can see that the bureaucracy kind of springs like a tumor from the executive branch. So where did all this come from. The bureaucracy is not really mentioned in the Constitution, okay, other than the fact that the Constitution assumes the president's going to need advisors, but not all of these many different agencies. So the bureaucracy is a gift of the progressive era. Remember, the progressives, they wanted to get stuff done. They favored centralization of government action. They put a big premium on efficiency and time management, and they felt that Congress just wasn't efficient. So about 100 years ago, they came up with this idea to divide politics and administration. Okay, politics is messy. That's all that discussion and debate. So they said, Congress, you can do your politics. And then we're going to delegate the power to administer the laws to the bureaucracy, to government administrative agencies. And these agencies are going to be run by experts that will be able to administer the laws in an efficient fashion. So this is kind of how it works. Congress is worried about, for example, climate change, okay, or pollution. And Congress passes a law, and the law says, you know, we want to have clean air, or we want to have clean water. But the law is very thin on details, because members of Congress, they can agree, oh yes, we need to have clean air, we need to have clean water, but they can't really agree on all the little details. Okay, what does that look like in real life? You know, what kinds of chemicals or emissions are we going to control, and at what levels? Okay, that gets very complicated and very easy to get gridlocked over. So Congress creates an agency, in this case the Environmental Protection Agency, and they delegate their power to the agency, and they say, okay, you know, Environmental Protection Agency, EPA, we want to have clean air and clean water, and we're going to leave the details up to you. We're delegating our power to you, and you can write the regulations about exactly how we're going to get there, exactly what emissions or what pollutants are not allowed at what levels. And so there's this separation of politics and administration, and this happens in many different areas. So Title VII of the Civil Rights Act, we'll talk more about that. We don't want discrimination in the workplace. Well, how do you define discrimination? Where do you draw the line between just rude behavior and behavior that should be punishable by law? We're going to leave that up to a government agency. We're going to delegate that power to the Equal Employment Opportunity Commission, and they're going to issue regulations and decide what laws against discrimination should look like. Okay, so there's this division between the mess of politics in Congress and the actual administration of these laws and the details. And the result is that we have all kinds of laws today that would never have made it through Congress. Many people don't realize just how entrenched the federal bureaucracy is in our everyday lives. So I'm just going to pull a couple examples for you of the ways in which we can run afoul of the different bureaucratic agencies. Up here on the left, you can see a little pond. There was a man in Wyoming. He had a piece of property out in the country. He had some cows. He dug a little pond on his own property so that his cows would have a stable water supply. It turns out this pond did not make the Environmental Protection Agency, the EPA, very happy. They said that before he built the little dam on the little creek on his property, he should have gotten a permit from the Army Corps of Engineers. And they threatened him with millions of dollars in fines. Fortunately, this man from Wyoming went to the courts, and he was able to work things out and get the EPA to back down. But the EPA is very aggressive with its regulations. For example, take the gas can. This is what a modern gas can looks like. The EPA has regulations for many different consumer products. Everything from soap to toilets to clothes washers, the light bulbs to refrigerators and lawn mowers. Okay, so they're trying to make things more energy efficient, more water efficient, etc. But the result sometimes is that these devices don't work as well as they used to. So in the past, gas cans used to have a little vent on the side. If you've ever used a large jug of laundry detergent, you know that there's a little stopper that you can unscrew to let air in, and it makes the laundry detergent flow out of the bottom better. And gas cans used to be built like that. Had a little vent, you could open it up and let air in so that the gas could flow out better. The EPA was concerned that people would be stupid and not use the vents correctly, I guess, and spill gas, and so they outlawed them. With the result that gas cans don't work very well, and you can actually go online and they have videos how to hack your gas can, which is probably a lot more unsafe than if the EPA had just allowed gas cans to be manufactured with vents in the first place. Then you have these Centers for Medicare and Medicaid Services that provide health care, or at least reimburse health care costs for the poor and the elderly. There was an organization called Caring Hearts. Caring Hearts provided home health care, and they ran afoul of the government agency, the CMS. The CMS said that they had engaged in Medicare fraud, and Caring Hearts said, no, we haven't, we're following the regulations. And it turns out CMS issues thousands of different regulations every year. Currently, they have about 37,000 guidance documents, and that's just what's available on their website, not the whole body of regulations. And it turns out there were so many regulations that CMS itself got confused and applied the wrong regulations to Caring Hearts. So Caring Hearts was correct. They were following the right regulations, but there were so many regulations that even the agency itself got confused. Let's talk about e-cigarettes. Now, I would never suggest to a young person that they go out and get addicted to e-cigarettes. E-cigarettes are just a nicotine delivery device, but they are much safer than traditional tobacco cigarettes. Okay, so e-cigs or vapes use water vapor, which is a lot safer than inhaling smoke from tobacco cigarettes. You may know that the Food and Drug Administration, the FDA, highly regulates cigarettes, and the question is, okay, how are they going to regulate vaping and e-cigs? And the answer is just as heavily. So even though e-cigs are better for you than cigarettes, I wouldn't say they're good for you, but they are much healthier than cigarettes, the FDA still heavily regulates them, with the result that the only companies that are able to manufacture e-cigs are the big cigarette companies, the big tobacco companies, because they're the companies that have the ability and the legal power to work through all the FDA regulations. So if you look at your e-cigs, you'll see they're probably manufactured by some of the big tobacco companies. The smaller companies just can't compete with all those regulations. The FDA also recently outlawed flavored e-cigarettes, which made my husband very unhappy. So now you can only get regular tobacco flavor and menthol flavor e-cigarettes, but you can't get any other flavors. And they did that because supposedly they were concerned that kids would be attracted to these flavors. Regardless, these are infringements on our freedoms that would never make it through Congress. Okay, if Congress tried to discuss and debate, it'd be a legitimate question. Do flavored e-cigarettes cause children to take up vaping? Because we definitely don't want that. Or is there some other way we can prevent children from vaping? But that's not what happened. What happened is the FDA just issued a regulation unilaterally. That's how they administered the law in this area. Okay. Marty the magician. So Marty is a magician in southern Missouri. He goes around to libraries giving a little magic shows for the kids. And the high point of his show is when he has his little pet rabbit come out of a hat. Okay, so very traditional magician show, and his pet rabbit is a crowd favorite. So one day he was giving his show, and then afterwards a lady from the Federal Department of Agriculture came up to him, and she says, do you have an official government license for your rabbit? And he said, no, actually I don't. And she said, you need a license for your rabbit, and you're also going to have a rabbit disaster plan. Okay, so this is part of having a license for your animal. Under federal laws, you have to have a written plan describing what you would do in the event of an emergency with your rabbit. So poor Marty the magician had to go and find an attorney and come up with a disaster plan for his rabbit so he could apply for a license with the U.S. Department of Agriculture. Again, significant infringement on his freedom. As a final example, might be interesting for college students, we now have what's called a sex bureaucracy. Obviously, we don't want sexual assault or rape to take place on campus, but we actually have bureaucratic agencies, rules and regulations that go into great detail about what constitutes permitted and unpermitted behavior, sexual behavior on campus. And they're using a very interesting set of values that perhaps are different from the values that many students would use. So all of these are ways in which government bureaucracy infringes on our freedoms. We know, as we discussed, that every time government takes an action, we're trading a little bit of our freedom for the government's promise of security. So we're going to look into this and say, okay, all of these rules and regulations by the federal bureaucracy, and of course you also have local and state bureaucracies as well, are they worth the trade-off from our freedoms? And is the current federal bureaucracy, is it even constitutional? So we're going to get into that discussion next time. So there are no readings for the next lecture. The founders did not anticipate the modern bureaucracy, so we're just going to discuss that without very much reference to the Federalist Papers. So have a great day, and I look forward to seeing you next time.